give you the examination bond notice of promotion.
That's fine.
Now we're calling out a case of State versus Ryan McKay Brunn. He's here today for two purposes. One dealing with a local rule, which is 10-day requirement for this court for a party who's placed into a local jail without bond. Also, the benefit of the court, we're here for an examination bond notice. He has not been presented yet to the magistrate. We ask you to go ahead and review that with him. There's actually a section on the back of the warrants to do that. There are two warrants in this matter so far. First is warrant number 2011 MGMW 4356, charged the defendant with the offense of murder. That was written and signed by the magistrate of this county on the 7th day of this month. For that offense, there is no bond. It's currently being held in the Cherokee County Jail without the benefit of bond. There is a second warrant as well charging the defendant on warrant number 2011 MGMW 4357 on the offense of false statements. That warrant too was written, applied for, and issued by the magistrate of the county on the 7th day of this month. And that, as to that warrant, if it is also held in place pursuant to the local bond schedule, like law will be set on that matter. I'll hand those two items over to the court now and ask the court to conduct the examination of our notice of 10-day hearing.
All right, Mr. How do you pronounce the name? Brunn?
Yes, sir.
Brunn, how old are you?
20.
How far did you go to school?
10th grade.
Can you read and write?
Yeah.
Are you under the influence of any alcohol or drug at this time?
Yes,
Is anybody here with you besides your lawyers? Do you have lawyers? A lawyer or lawyers?
Yeah.
And do you know who they are? What are their names? Brunn and Mr. Cannon, you met with them today?
Yes.
Have you met with them before today?
Yes, sir.
All right. So far, are you satisfied with what they're doing for you? All right. Do you understand what you charge with?
Yes, sir.
You have two offenses here. One is the offense of murder. The other is false statement. False statement has a bond set by schedule posted in the jail. For that offense and for most offenses, as soon as you enter the jail, you can make bond and you have the ability to do so. However, for the offense, that bond is set by schedule posted in the jail. The other offense, the offense of murder, the only way you can make bond is if the Superior Court judge sets bond. I'm a Superior Court judge. I can do that. I'll consider that when a motion is filed to that effect by your lawyers. Right now, I'm going to do is advise you of your rights. You understand that? You have a right to remain silent. Anything you say can will be used against you in court. You have a right to have an indictment by the grand jury. The next time the grand jury could possibly meet to consider your case will be the second Monday in December, which I guess would be this coming Monday.
Yes.
Sounds unlikely. I guess it wouldn't be at the earliest would be in January, but arguably it could come up as early as this Monday. You have a right to have a pre-indictment probable cause hearing. If you wait until after indictment, it will be too late for that probable cause hearing. If bond is set in your case and you make bond, you give up your right to your hearing in that case. You also have a right to a trial by jury. You have a right to have a lawyer represent you. You cannot afford one to be appointed for you, no expense to you. As far as you know, then, have you made a request for appointed counsel, or were these appointed for you without request, or do you have anybody hiring a lawyer for you, or do you know? You're going to use these counsel. All right, these counsel will represent you in the case. You have a right to a trial by jury. Anytime you will give up the rights I told you about and interfere guilty, then you notify the sheriff who has you in custody and or counsel, and you know to draw back before the court sets a plea. Now, I think we've covered everything that's in the normal magistrate appearance hearing also, except for the scheduling possibly of a commitment hearing. Has that been done, or y'all, you want me to try to deal with that some way? I think the magistrate is present, but y'all want to work that out with counsel.
No, sir. We will file a motion for that at the appropriate time, confer with this attorney's office, schedule a time, date for that to occur.
All right. Anything else that we need to cover as far as counsel for the defense or the state?
Your Honor, I have been presented with some motions today. When we walked in, most of those are boilerplate standard motions for discovery. There is a motion, which is motion number 5, and it's a complete recordation of transcripts of proceedings, and also motion number 6, which deals with examining and testing physical evidence. I I'm not sure if there's anything that needs to be addressed to those two matters right now or not.
Well, we have a staff response for motion to record. You can go ahead and prepare if you want to, Mr. Cannon, basically saying that we will grant that motion. However, this order is not a substitute for diligence of counsel. Words to that effect.
I understand.
Anything else?
On the motion to inspect and examine photographic test physical evidence, put the attorney's note on notice that crime lab shouldn't destroy any evidence that they secure, and until we've had an opportunity to see what that is and file appropriate motions, just putting them on
You
notice.
probably need, well, you put the DA on notice, but I think you're aware that you cannot serve the law enforcement agencies through the district attorney's office. So there are some bases for the DA being required to notify you of things he intends to have to serve that on any agency that you want to be bound by. Otherwise, you may be unprotected. Anything else?
That's all I have.
Anything else you can think of? You can count.
No, sir.
That includes the matter. We adjourn.
All right, you conclude that
Yes.
What's your name, sir?
Jesus Palomino.
Who are you related to?
I'm not related to anybody. I used to live in the neighborhood. I lived there. I came because I want to know what's going to happen with this guy. I don't ask for them to give him death or anything, but I do want justice because it's just unbelievable, man, how something like this can happen. My cousin was her best friend, and it tears me to see my little cousin in tears every day, thinking about her. And it's incredible that somebody can do this. And I just want, justice with this case. I don't ask for anything more.
So you live in the Woodbridge apartment?
Yes, sir, I do.
Did you know this guy?
No, I had seen him. He did look suspicious before this even happened. He would look at people in a bad way, It just wouldn't. It didn't feel right when this guy started working there. I never trusted him.
Jesus, I know yesterday you said that you still feel there's still really not a sense of comfort or closure. Seeing him in court today, did that make a difference?
No, it still doesn't because, like I said yesterday, it could happen again with anybody. You can't trust anybody. I personally can't trust anybody now. It's hard living in the apartment complex now.
What made you come out here today?
Because I want to see justice be served.
Is it that you want to see him in person? What was it about being in the courtroom for his first appearance that made a difference for him?
I wanted to see him. I wanted to see the criminal, in person. I came to see what was going to happen because I think if they don't do anything about it or they don't do something about more than just giving him a few years, I think it's just not going to be fair.
Do you think a mother of the victim's mother wants to see what that about you?
I personally don't wish that on anybody. That's not me. I just want justice to be done.
What was your cousin's? What is your cousin's name?
Shedley, Litzy Yepes. Litzy Yepes, Litzy Litzy, Yepes, Yepez.
Okay.
Yes.
Have you ever told him like yesterday afternoon after everybody got home and got settled and knew that this man was going to
my mom and I were a little bit settled, but not fully because, every time we go out the door now, we got to look both ways to make sure that there's nobody there, so we can feel safe and walk outside of the house. So it's not fully controlled yet. It's not fully. I think we would have to, see a counselor or something because it's hard.
What about your cousin? The little kids?
My cousin can't sleep at nights because she thinks about her all the time. So it's hard, I don't know. They don't let them go outside anymore because of this. They're thinking about moving out because they don't want anything like this to happen. She is 6 or 7 years old. Yeah, she was in the same class as her.
Palomino, right?
No, my name, yes.
And you were here.
Jesus Palomino. I had seen him. Yes.
I've heard reports that they've been unreceptive. Do you feel that way?
Yeah, I don't think they've been concerned enough with people that live inside of Riverwood. I think they should have sent out a letter, regardless of whether people knew. I think, it's best to notify people, because when I got home from work, I didn't know anything about it until the next day.
How do you feel about the efforts by the police and authorities?
You know, I would honestly have to say that, in my opinion, it wasn't done enough if she was found in the trash can inside the apartment complex 3 days after the missing child was, you know, I don't think personally it was good enough.
Can I ask your age? 19.
Yes, sir.
Do you attend local school?
No, I yes, sir.
No, that company just rough right now.
Yes, yes, ma'am. They were in the same classroom.
What was your first name again?
Jesus.